It now gives me great pleasure to introduce the next speaker, who is Dr. David Khan. Of course, no stranger to our area in health law. A person with lots of experience and a partner with Howse Williams. So he's going to tell us more about developments concerning the Medical Council of Hong Kong and its decision. So with this, it's over to David.
Thanks very much, Kelvin. I hope you can hear me and see the screen. It is absolutely my pleasure to join in the presentation tonight. May I first begin by saying I wish everyone good health, which is very important at this time. So what's happened at the Medical Council of Hong Kong recently then? Let me see if I can turn the slide. Right. If you look at the statistics published in the Medical Council newsletters, the top line represents the total number of complaints received by the Medical Council. They are adjusted figures, meaning that every year you get peculiar complaints whereby for a single incident the complainant has made over 1,000 complaints, so artificially inflating the total number of complaints overall. But if you disregard those, you will see there is clearly a trend upwards. 493 cases in total received by the Medical Council in 2016, all the way up to 714 in 2020. Interesting for me. Looking at SARS in 2003, immediately after SARS, you saw a decrease in the number of complaints for the year or two after that, but no such luck this time. Now, if you look at the breakdown of cases, the top three types of complaints received by the Medical Council are convictions in courts disregarding professional responsibility and practice promotion. I'll say a bit more about the top two. I don't know if you can see my pointer, the arrow, sorry. Convictions in court, as you can see, 58 complaints received in 2020. Most of them are minor road traffic accident cases and road traffic offense cases, and they don't go any further beyond the preliminary screening. But as you will see, some of them do go forward to a full inquiry, and I'll examine that in more detail. Disregarding professional responsibility, I call them clinical cases. Normally, about 80% of cases received by the Medical Council each year are the clinical cases. If you then take a deeper dive, what are the clinical cases? Well, really anything goes. So I would say in the entire process of healthcare delivery, every aspect has been the subject of clinical complaints, from diagnosis, advice, executing the treatments. Now, with that very brief introduction, I have two topics I want to discuss, as I said, the criminal convictions and the clinical cases. I do apologize. Just now, the slide was referable to cases up to 2020. This slide is referable to 2021. 30 inquiry hearings before the Medical Council last year. Looking at them, actually, my team and I did a large proportion of them. You will see that 6 cases out of 30 were indeed to do with criminal convictions, more of that. And they're, roughly speaking, half of the cases before the Medical Council that go all the way to the Medical Council hearing are clinical cases, and then there are the practice promotion cases. So let's be clear, when I say criminal convictions, these are cases already, the defendant doctor had already been convicted in the criminal court, and then since they are doctors, they come before the Medical Council. The way it works is this: if a doctor is convicted of a criminal offence. By that I mean if he pleaded guilty to the offence or he tried to defend but failed and was convicted, then within 28 days of the conviction, the doctor has a duty to report his conviction to the medical council. And one thing to note is that what matters is that the nature of the offence is punishable by imprisonment. So even though the doctor is only sentenced to something short of an imprisonment, the fact that the nature of the offence means it was punishable by imprisonment, that in itself means it's reportable. So what I mean is, if I walk into 7-Eleven, I stole a pack of sweets, that's a theft offence, punishable by up to 14 years imprisonment. But if I only stole a pack of sweets, I'm unlikely to be banged up. But the conviction itself, since the offence is punishable by imprisonment, means that I have to report it. The bottom bullet point is important. What the medical council is concerned about are cases which could have a potential bearing on the doctor's practice of medicine. So as you can see in the bottom bullet points, those are offences to do with indecency, dishonesty, violence, drug and alcohol related, which in a way could be seen by the medical council as having a bearing on the practice of the doctor. Another consideration they have is that the public should be entitled to assume that all doctors which patients come across should be of unquestionable integrity. So if there is any implication there, once again, the medical council will take an interest. What is important is that when it comes to an inquiry and the more serious offences, other than the road traffic offences, could well come before the medical council. What is important to bear in mind, the medical council is not expected to look behind the conviction, i.e. very often, perhaps it can't be helped. Doctors feel they have been wrongly convicted, they have been hard done by the criminal courts. But I'm afraid the medical council will not question the conviction. If the doctor was convicted, then that's the end of that. There is a Singapore case known by Isaac Rattam, where it says only when there are really exceptional circumstances would the disciplinary body, in that case it was the for solicitors, would the disciplinary body look behind the offence. But that, I'm afraid, almost never works, because those convictions, surely the court will, and the medical council will say there was the possibility of appeal. You either didn't appeal or you appealed and lost. So as a result, they won't. They will take the conviction as read and will just, and importantly, under the bottom bullet point, it says, as long as they are satisfied, and they almost certainly will be, that there was a conviction, that equates to misconduct, and they will go ahead to sentence. And perhaps that's where we come in as your defense doctor at the medical council inquiry. It is important we prepare in advance and give a very thoughtful, detailed mitigation submission on your behalf to try to persuade the medical council that despite the conviction, it wasn't as serious as it seems, and you are still fit and proper to practice. In short, before the medical council at the hearing, there would be, in the usual way, a lot of materials for the medical council to consider, such as transcript of the criminal hearing, certificates of conviction, even appeal judgments, and the kind of key materials as to what happened leading to the conviction. And in short, our job as your defense lawyer is to try to address the medical counsel as to the circumstances that is not as serious as it appears. One technical point, and I'm conscious that the audience tonight, some may be non-lawyers, but one technical point is that the medical counsel is expected to review the materials and come to his own views as to seriousness. So it shouldn't just adopt the views made by the criminal trial judge or the appeal judge. So, and in the cases I've come across, and in the judgments, including the I think 6 judgments from last year, the medical counsel are conscious of that, and they point out in their judgments that they have thought through it and come to their own views. What is important when we make submissions on your behalf, we will try our best to demonstrate that we can't turn back the clock, but that the defendant has learned his lessons, he has insight into his mistake, and is remorseful. Now, I'm afraid that submission is possible only if the defendant, it works best if the defendant pleaded guilty to the offense at the criminal court. And it doesn't really sit well with a defendant who pleaded not guilty and then is found liable. But in any event, when doctors come to me at the earlier stage, at the stage of the criminal offense, at the stage of the criminal trial, my advice would be, don't worry about the medical counsel proceedings, which will come if you are found guilty. Just focus on the criminal proceedings and do the right thing. He shouldn't plead guilty or not guilty with a view to achieving a better result at the medical counsel inquiry. Another concept is this: the fact that the doctor was found guilty at the stage of the criminal trial in itself implies that at that juncture the doctor was unfit to practice medicine, and there is that assumption. And what we hope to show is, despite that, since the time of the criminal conviction, the doctor has rehabilitated himself, so thereby he is now up to standard, is now fit to practice. Now, how do you rehabilitate oneself? Depends on the nature of the criminal offense. So let's say it's an offense of a sexual nature, and if it is correct, then we hope to show that, say, the defendant doctor at the time of the committing the offense was under the influence of a psychiatric condition. He has sought treatment since that time, and he has been treated. He is now in remission. He will continue to undergo monitoring by the treating doctor. There are other potential measures, but it has to be referable to the nature of the offense in the first place. But perhaps we can show beyond that, the doctor has also or has agreed to put in place a supervision scheme by senior doctors to monitor his clinical practice, making sure he will always be accompanied by a chaperone in performing examination of the female patients. So it has to be thought through and prepared in advance. My last slide on this topic. Well, we do our best, and in the right cases, we have achieved a suspended sentence, a deferred sentence, meaning that the doctor's name stays on the register and can continue to practice. Although I'm afraid in some cases, the medical counsel have or had sentenced to an immediate removal. then we plan to the next step, which would be the restoration hearing. It is similar considerations, but obviously in a more subsequent point in time. So that's all I want to say under the second topic. My third and final topic is to do with the clinical cases. Now, in the cut and thrust of medical counsel inquiry hearings, I've certainly, in recent cases, debated this issue regarding particulars of charges, and I'll explain to you what I mean. I'm afraid that as a result, I don't suppose I'm popular anymore in front of the prosecution team at the Department of Justice. Although, joking aside, I'm pleased to say in those cases, the medical counsel have looked at the arguments carefully and fairly in coming to a decision. So what do I mean by all that? In clinical cases, and I do pride myself in staying updated on clinical medicine topics, it is very important to take an early and careful view of the case and look at the allegations. Now, I'm always interested to see how, given a set of facts, let's say an operation that resulted in an unfavorable outcome, how come the medical counsel look at those facts in a case and come up with a set of allegations? I'm always interested, and you have to examine it carefully. But suffice it to say, and as most of you would be aware, very often there are multiple allegations or charges. Very often, each allegation or charge, you call it an allegation at the PIC stage, screening stage, you call it a charge at the inquiry hearing. But very often, each allegation is a mixture of questions of fact and law and expert opinion. One example would be an allegation of the doctor omitting to mention the risk of perforation for an endoscopy. Thereby, he failed to obtain informed consent. So that quite nicely is an allegation in three parts: fact, law, and experts. Now, whereas at the early screening stage of the PIC, preliminary investigation committee, arguably the medical counsel do not have a duty to give details of the allegations, but surely certainly by the time of the inquiry hearing, once it's been referred by the PIC to an inquiry, then the allegations would be crystallized by that stage into definite charges, and it will be too late usually for the medical counsel to change the charges once they are set up, and the charges have to contain details. We call that particulars. Why is that important? And so what the debates I had with prosecution were about, you see, simply put, the prosecution has to proceed their arguments, their case, based on the charge or charges. They can't deviate from them. They can't set out certain charges and then pursue different charges or a more serious set of charges. The charges are what they are, and they are stuck with them. Not only that, then if you go back to my example of failure to explain perforation in an endoscopy, they have to adduce sufficient evidence of fact, of expert evidence, and law to prove the charges. Now, it seems straightforward enough, but that we are always very careful to assess a case defensibility of a case in this way. Very often when I work with especially when I work with the junior lawyers, they are very eager to tell me what the defendant has to say. The defendant has an explanation. But really, the most important thing before you even come to the defense case, you look at the prosecution charges and what evidence they have. It sounds perfectly logical, and indeed it is. Now, where it becomes important is this, and I've certainly seen that, and in actually not this slide, but the next slide, there are case examples where the prosecution stated one charge, and in the case of Dr. Wu, I'm not going to give the full name, and Dr. Lam, they did that. The charge is a substandard, let's say, explanation for a surgery. So that is to do with the allegation or the charge is the doctor was below standard, and yet insufficient explanation. Yet at the inquiry, the prosecution pursued a more serious charge, which is not the charge written down. They pursued a more serious charge of the defendant doctor deliberately misleading the patient. Now that is a dishonesty charge, and that's a much more serious charge. So our objection would be, A, you didn't tell us so. You didn't say that's what you are charging us for. And B, you don't have strong evidence to prove such a serious allegation. And it's important we raise objections at the inquiry. And often the medical counsel is receptive, they are fair, they agree with our objections, and then that charge would fall away. And if, unfortunately, if the medical counsel is not with us, then we make our objections, and it's open to us to appeal against the judgments if the doctor is found is convicted of misconduct. As I am saying all this, I am acutely aware this is quite technical, but it's important for us, and it's certainly a key issue in some of our clinical cases, some of my clinical cases recently. Before I leave you, one other example, and it's a dental counsel case, and with a citation here, is a different kind of defect, where the charge was that the dentist failed to consider a particular dental condition. Therefore, he was below standard. Now, in that case, the prosecution didn't come up with expert evidence to show that dentist should have considered that dental condition, if you still follow. So the objection would therefore be, well, you haven't proved your case, so the dentist shouldn't be found guilty. So I hope I've made all these clear and understandable enough, and once again, I fully appreciate they are fairly technical issues. With that in mind, I've overrun a little bit, for which I apologize. So in summary, I would say that these are not new developments as such, but really they are recurring themes which we still come across in our cases. That's all I'm going to say. I'm happy to take questions later on, and I look forward to listening to the upcoming speakers. Thank you.